interest, my lord. It's a basically loan, my lord, with a 5% interest, with a promise to return. As I have failed now, I have returned 10 lakhs also, and his case is that I have returned 10 lakhs. And apparently when there is the money of
Just let me have a look. Huh? I just
man.
so basically this amount he had paid, and thereafter he returned 10 lakhs. And
As per him, my lord,
due to not returning of the
Yes,
other
yes,
amount,
this
this
is-
has been.
and he himself said it is a case of with a 5% interest, my lord, personal loan. Nothing more than that, my lord.
Cheating.
There's no ingredient of, my lord, cheating and the 406. It's basically when they admit
The jurisdiction would lie, right? The informant is from here,
informant is from here.
but the money was delivered
Money was delivered
Yeah.
in Assam, my lord.
Assam.
Even then case has been registered here.
Acha.
But the,
Cases no.
my lord, apparently 5% interest, the lordship knows it, my lord, there has to be initial deception. Yesterday, even as beautiful judgment has come. No initial.
Yes, let him maybe call for.
Yes, sir. Let him record his statement.
Yes, Lord.
We can ask him to record his statement. Huh? A.M. Bora, Learned Senior Counsel, assisted by D.K. Boydha, Learned Counsel, and L. Hage, Learned Additional PP for the state, invoking for a 482 bill in connection with Doimuk PS case number 75 or 26 under so-and-so section. Full stop. The case arose out of a complaint lodged before the police on 26/6/2026 by what is the name of the informant?
Tak Ridi.
By one Mr. Talak Ridi. Full stop. The gist of the allegations was that he got introduced to the petitioner through one person named Bhobesh Kosari, and that the petitioner was working as DDC in Dhemaji district. Subsequently, a cordial relationship developed between them, and the said person, the petitioner, requested him to lend rupees 3 crores with the assurance that it will be repaid with 5% interest. However, he refused any written document. Thereafter, it is further stated that thereafter, the said money was given in
Out of 3 lakhs, 2 points, 2.11.
2.1 crores, 2 crores
11.
11 lakhs 82,009. Full stop. But subsequently, it is alleged that subsequently the informant started having doubts about his intentions, and despite and after repeated reminders, the petitioner returned an amount of rupees 10 lakhs and has not yet returned the remaining amount. And that the petitioner claims that he has links with important people in the government of Assam. Full stop. The Learned Senior Counsel submits that it is essentially a monetary dispute which has been sought to be criminalized by lodging the FIR. They submitted that the petitioner is willing to render his full cooperation to the investigation. On the next paragraph, the learned additional PP submits that case diary would be necessary. Next paragraph. Call for the case diary of so and so police station.
Scan copy, Lordship.
Scan copy of the case diary. However, with a view to enabling the petitioner to record his statement and his version of the events dash, it is directed that in the interim, in the event of his arrest, 50,000 with one security, subject to the following conditions: that he shall render cooperation to the investigation, shall not hamper or tamper with evidence, shall appear before the IO, comma, making himself available for examination. List on. When do you want? Will you come physically or online? This Thana is how far? Within which district?
This UPL, Lordship.
Okay,
On 13, my lord,
13.
13 if possible. Published.
13.
Item number 4.
May it please your lordship,
Yes,
my learned senior counsel is on legs before court number 2
the other court. After some time.
after some time. Hello, guys.
Item number 7.
My lord, I need some time to take steps upon the respondent number 1, 4, and 5.
1, 4, and 5.
Yes.
Total 4 respondents.
Yes,
Just you
4,
take the,
2, and 3.
you take this,
Can I
just
consider it?
1, 4, and 5. 2 and 3 have appeared.
Yes,
You have appeared.
Yes.
Full stop. Heard learned counsel.
Preparing for a tea tango.
And madam's good name
P. Wangmu.
for respondent number 2 and 3. Full stop. The learned counsel for the petitioner submits that he may be granted some time to take fresh steps
Yes, sir.
upon respondent number 1, 4, and 5. Full stop. The prayer is allowed. Fresh steps by speed post.
Yes.
By fresh steps may be taken by speed post. This is the matter. After
After 3 weeks, ma'am.
3 weeks.
Much.
In the orders column, after 3 weeks.
Item number 8.
Paper book, yeah, it's ready. Yeah, that's what you were saying. So just we wanted to see the record. You give this thing. May give the names. You're Mr.
Yes, Your Honor, the correspondent number 2.
So you're for the informant.
Yes.
Madam, you are appearing, Jim, for the state. Full stop. The scan record is also available, I believe. The scan TCR is scan or original? The original TCR has been received and the registry has also prepared a paper book, copy of which has been received by the respective learned counsels. Ms. Jenny, learned additional PP submits that the matter may be posted for hearing. Accordingly, list, we fix a specific date or leave it to the registry? List after 2 weeks and for hearing. It has been admitted?
8, 12.
Yes. The appeal was admitted on 8/12/2025. List in the hearing column after 3 weeks on a date to be fixed by registry. Okay, after 3 weeks.
Item number 9.
Yes, my lord, this matter was, my lord, listed twice, and on the very first date, my lord, the notice was issued to the victim also.
Hmm.
And my lord, it has been flagged in the record. The notice has duly been served to the victim.
Served.
Yes, my lord, its a flag mark is there, my lord.
Then we can appoint an
Yes, amicus or the legal aid counsel, my lord, to represent the victim.
amicus. Just a minute. I'll look. heard learned counsel for the appellant. And I think learned counsel, learned additional PP for the state. Will stop. The learned additional PP points out that as per office note dated service report. Where is the appeal memo? The appeal was admitted on 2/9/2025. Original case record has been received and paper book has also been prepared in
Received also.
adequate sets, which have been received by the respective learned counsels. I am unable to locate the office note. The service
And
report is also there.
In office note, it is not mentioned, my lord. Actually, service report is there in the, my lord,
Okay.
flag mark.
Where is the cost title at page? I'm not. You have implemented the victim or the informant?
My lord,
No appeal
no,
has been filed.
my lord, actually,
No
through-
implement.
it's from legal aid council.
No.
She was, the victim was not implemented, but
Victim
notice was.
cannot be because POCSO case.
Yes, my lord. It was,
Informant.
notice was served through, my lord,
Because
by
it is,
notification 17, my lord.
Because it was mentioned that it is duplicate copy of service to the victim and other documents.
Yes, my lord.
So and so. Victim is 14 years. Anyway, so she is not appearing.
Yes.
None has appeared on behalf of the private respondent who was noticed as per the report dated 7/11, 7/10 or 11, 7/11/2025. Therefore, we'll appoint an amicus
Yes, my lord.
legal aid counsel.
Yes, my lord.
You can suggest someone.
Ali?
Huda,
My lord,
you can suggest because I'm not so familiar.
okay, my lord. My lord,
With the
some of the legal aid councils are available, my lord. Among them, my lord,
Please.
But she's also one,
Yes, ma'am. Yes.
her name is also there, man.
Your good name, please.
Dirilong,
Yes.
Dusurilong.
Learned counsel is hereby appointed as legal aid counsel to represent the respond number 2. Stop. She may be furnished with copies of the appeal and also a set of the paper. Okay, do it. You'll do well.
Obliged.
Registry will give you a paper book. No? The registry shall furnish a copy of the paper book to the newly appointed learned legal aid counsel.
Let it be, my lord, listed after 3 weeks, my lord.
Yes. List the matter in the hearing column after 3 weeks.
Yes, my lord. Obliged, man.
Item number 10,
This is lost in the file. This one. Yes.
Yes, if I may, my lord. My lord, as directed me to inquire whether the affidavit of assets was filed before the learned.
For that
magistrate
matter,
court.
right?
Ah, yes, my lord.
Hmm.
My lord, I received the file yesterday
Mhm.
and upon perusal, my lord, in their revision petition that was filed before the learned session court, they have annexed the affidavit of assets that was filed by us before the learned magistrate.
It was not filed before the original court, but it was filed before the sessions court.
No, my lord, it was filed before the magistrate court, wherein the
Also.
enhancement petition
It was,
pending.
okay. Okay, it was filed before the original court also.
Yes.
Original court.
Magistrate court.
Magistrate court,
Ah.
my lord.
Then it's okay, no problem. They had all the materials. From there, probably it was this reference to his income
Yes,
was made.
The learned session court have gone through the materials and then
Hmm.
arrived on the decision that is been impugned herein.
So, should we take it up for
Yes.
this thing now?
Yes.
for the interim.
for the interim, my lord.
Yes.
If I may. My lord, our main grievance with the impugned order is that, my lord, that the learned session judge, the session court, was sitting in a revisional capacity, my lord, when the impugned order was passed, my lord. So it was not in an appeal, my lord. So as my lord knows, my lord, in an revision petition, my lord, the learned court has to examine the legality, correctness, or propriety of the impugned order, my lord. However, it is our submission that, my lord, the view which was given by the learned magistrate court while rejecting the enhancement petition was substituted by the learned session court, saying
By its-
impugned judgment
By its own calculation.
by its own calculation, my lord. If I may take your honor, my lord, to through the orders, my lord, if that can be
Ah.
done, my lord.
Yes.
My lord will find the first order at page number 27 of the criminal petition, my lord.
So at the final hearing, Ms. Jenny,
Yes,
this point
yes,
would become kind of a legal issue, legal point,
yes,
that whether, whether the revisional court can enhance it.
yes,
The enhancement was dismissed.
yes, Your Lord.
So,
The
mm.
prayer for enhancement was dismissed, Your
Mm.
Lord. And on the party has
when
denied that
when it was
dismissal order.
challenged, it was set aside in a way. And after setting aside, it was enhanced by the
Yes,
revisional court,
yes,
whether that would be permissible in
yes,
law.
yes.
Right. So, but that will be for the final hearing,
Yeah, absolutely.
final hearing. So now we are in the, it
Interim.
would have a small impact on the interim also, that aspect. But anyway, the main aspect has to be decided at the stage of final hearing, that issue. Today we can just touch upon it, that's all. Okay, page number.
27, my lord.
Mm. Anyway,
Yes, my lord. My lord, the last paragraph, it says that the order for maintenance was passed upon the consent of both the parties, my lord. The 10,000 and the academic, the expenses that would be incurred for the child, my lord.
Mm.
That was there. Now, after a point of time, this was passed in the year.
this was passed by the session judge.
No, my lord, the magistrate court, my lord. The learned CJM Alo, my
Are we on the same page? Annexa 1, page
lord. Yes,
21,
page number 27, my lord.
27. Yes, I am there only. Civil Judge Senior
Civil Judge
Division.
Senior Division, CJM, my lord.
Oh, I see. He was the then CGM
Yes,
at
my
the
lord.
time.
Then in the year 2000,
see,
it was
yes.
passed in the year 2017.
Mm.
Then they filed an enhancement application in the year 2022, my lord.
Mm.
Miss case number 73 of 2022.
Page.
The page will start at page number 28, my lord. Annexure 2.
Okay. This was the miss case.
This was the miss case. This is the order of the miss case, my lord, wherein
Page 28.
page 28. It is the order
Okay.
wherein their application for enhancements was rejected, my lord.
Rejected.
Now, my
Mainly on the ground that the child's mother
yes, my lord.
was earning.
My
That-
own-
mainly on that ground.
Yes, my
That
lord.
day we had seen. So this was passed by the CGM, West Siang, Alo.
Also, my
Oh.
lord, the mother was also earning, and
Mm.
also there was a observation that the father cannot absolve himself of any liabilities just because the mother is earning.
Certainly.
So both of
Mm.
them should
Mm.
look after the child
Mm.
combinedly, my lord, together. However, my lord, what I'm trying to emphasize with that, my lord, in this order, my lord. In the revision petition, in this order, all the materials were placed before the learned magistrate, my lord. He took a call basing on the affidavit of assets of both the parties. And also, my lord, the reason, if my lord will see, there.
The enhancement that was prayed for was
madam.
40,000, like 50,000.
for-
From 10,000,
Yes, my lord. 30.
the petitioner wanted 50,000 rupees,
30,000, my lord.
30,000,
30,000.
20,000 increase.
Now, my lord, we have annexed their application for enhancement herein, my lord. It starts at page number 69, my lord. Their application for enhancement. Now, basically, my lord, it is not disputed that even at that point of time, the respondent number 1 was earning around 1,50,000, and she has some residential properties as well, wherein she's getting rent. Now, how much rent she was getting, that has been disputed, but it has not been disputed that she was getting rent from, she has some structures, my lord, wherein she's getting some additional income. And her admitted salary was 1,50,000, which at this point of time, as informed, is around 2 lakhs, my lord, more than 2 lakhs, just above 2 lakhs right now. Now, the reason, my lord, why she says that she needs enhancement in one of the paragraphs is at para number 9, page number 75, my lord. Herein she says that she is
So the 10,000 per month order was passed on
in a
2017,
2017, my lord.
2017.
Yes, my lord, 2017.
2017. And in 2023, this was filed.
Yes, for
2023,
enhancement.
which was disposed of in November
No,
23rd, 2023. So 17 to 23,
Yes,
an elapse of 6 years.
6 years, after a lapse of 6 years. Now, my lord, at that point of time, the child, when the order was passed, it is contended that at that point of time, the child was 5 years old, my lord. And after that, he grew up, so the expenses increased, my lord. So now, basically, my lord, what they are contending is that at page number 75, they are saying that she's suffering from some heart disease. So she has to take some treatment, due to which nearly the entire part of her 1,50,000 salary goes into medical treatment for that. disease.
75.
Page number 75, para number 9, my lord. My lord, if I may read the para.
Yeah.
That the applicant number 1 is serving as an assistant project manager, women development, and is earning a monthly salary of rupees 1,50,223, and have some income from few rented house, but she is a heart patient and is suffering with intermittent arterial fibrillation and is taking treatment at Dibrugarh, and she need lifelong medicine and regular periodic checkup in well-equipped hospital, and as such, the income of applicant number 1 is not at all sufficient to fulfill the basic need of both the applicants, as because in the present context of inflation and the rise in the cost of living, the meager salary earned by applicant number 1 is not at all sufficient to meet up the basic expenses of both applicants. My lord, firstly, a salary of 1.5 cannot be categorized as a meager salary, my lord. People are running homes at 30,000, 40,000, my lord. 1,50,000 is not such a meager salary,
Yeah.
my lord. And secondly, my lord, in support of her, this averment, she annexed only 2 documents. One is a prescription. Second is an to whom it may concern certificate by the concerned doctor, saying that she is undergoing some kind of a treatment. However, my lord, it is upon her to show that the expenditures, my lord, certificates are just description of what she's undergoing, and that is also subject to proof, my lord. But if she is indeed, my lord, spending nearly 1 lakh, more than 1 lakh rupees upon her treatment, she will have some breakup, my lord. She will have some documents that was not provided in the applications. We have annexed those those documents as well, my lord. If my lord would like to see, those documents are
No, it's okay.
Therein, my lord.
We will not go too much into detail because
Yes, ma'am.
that will be at the stage of hearing. Can be disposed of
Yes, ma'am.
shortly after we get records have not come, right?
No, ma'am.
No, we'll
Actually,
call
we
for
should-
the records.
Yes,
We'll take a call on the interim issue
Yes,
and then call for the records,
Yes.
right?
actually, my lord, after going through the revision petition as well, my lord, if the records are called,
Hmm.
the petitioner in his written statement before the learned magistrate while hearing this application had submitted nearly 50, more than 50 to 100 pages of medical documents, whereby the expenditures of all his dependents have been shown, my lord,
The husband.
the husband, my lord. And even if my lord will kindly come to page number 14, my lord, we have also given a breakdown of what the expenditure I'm incurring for my dependents as well, my lord. Page number 14, para 6, my lord, there is a breakdown of all the expenses, my lord. The medical expenses, self, the family members, my unemployed children,
Page.
page 14, my lord. If page 14, the middle part, my lord, I have given a breakdown of everything.
The present respondent
Yes, my
is his second wife.
yes, my lord. So the maintenance was only for the child only, my lord. So now these are all the dependents and what I'm incurring every month, monthly. And I'm also to retire next year as well, my lord. Now, my lord,
He claims to have a lot of liabilities.
lot of liabilities, more than what he is earning actually, my lord, at that point of time when the enhancement was filed. So, my lord, if I confine my submission herein, my lord, that I have presented my liabilities before the learned magistrate. The respondent number one has also presented her liabilities and her income, and accordingly, the magistrate has taken a call. Now, my lord, if the impugn order, my lord, if that we are challenging herein, if it is seen, my lord, the decision, the operative portion will start from page number 22, my lord, para number 41.
Yeah, page 14.
Yes,
Page 14.
oh no, my lord, page 60, para number 41. Page number 60 of our petition, my lord.
Right.
Now, my lord, if the whole order is seen, the para number 42, 43, 44, 45, and 46, my lord, it is our submission that the learned revisional court has substituted the view taken by the learned magistrate on regards to the same material in a manner, my lord, the version of the petitioner has been disbelieved and the version presented by the respondent number one has been accepted by the session court, my lord. Because, my lord, there is no discussion regarding why the documents that was presented by the petitioner in his WS regarding the expenditures have been disbelieved by the learned court, my lord. If the learned court is believing that the respondent number one has some financial difficulties based on the materials placed by her, then, my lord, there should be a discussion regarding why the documents, the medical documents, everything that I've submitted have not been considered by the learned court, my lord. And also, my lord, in regards to the quantum, my lord, the enhancement is directly from 10,000 to 30,000, my lord. Now, my lord, this, even if he is a 12 or 13 years old child, my lord, the maintenance amount was of 10,000. Now, if there is an increase in his needs, my lord, there should be in my humble submission, my lord, there should be a description of how the breakdown has been arrived at, my lord. From 10,000 to 30,000. My lord, 30,000 for an 13 years old.
No, that's not the issue. I mean,
Yes, ma'am.
people, all depends on your means.
Yes, my lord.
So there are two issues here in this petition actually. One is the basic issue that whether, as you have contended, that while hearing as a revisional court, whether it could, substitute its own view and enhance it. And secondly, if so, if not, then it goes there only. If so, if the court is permissible to enhance it on its own also, then whether the enhancement is justified as far as the mathematics is concerned.
Yes, ma'am.
Right? That's all.
Yeah.
That is the issue. That is the issue in the main matter.
Yeah.
But we just touch upon it because you are seeking a stay of the matter. Anyway, this has to be expeditiously disposed of
Yes, ma'am.
after calling the records. Basically, this much is your submission.
Yes, my lord, because my lord, even in the execution, my lord, that why we are pressing for the stay was that because as in the revision petition, my lord, direct order is given to the DDO for deduction.
No, that can be
That is
given,
there.
but you are challenging the order
In a
for
at
other reasons also.
Your Lordship. Lordship, prior to the impugn order, I would just like to brief Your Lordship that, first of all, when the order was passed in the year 2017, Your Lordship, it's only from 2017 till this date, Your Lordship. Even the amount of 10,000 has not been paid, except for 10 instances, Your Lordship. And neither the school, if Your Lordship will see the last paragraph of the first order, Your Lordship, where the 10,000 entry was given, Your Lordship, at page number 27.
27.
Yes.
No, that has to be cleared.
Yes.
Why that has not been cleared? At
My
least
lord,
Now,
you have no dispute over 10,000. So
Yeah.
that 10,000,
it was
no,
a consensual.
at that time, the 10,000, he has no dispute with the
No,
10,000.
no.
He's willing to pay
Yes.
10,000. So at least with regard to the 10,000, there should not be any area.
Yes,
Right.
they in fact, they have only on the 10 instances they have paid thereafter till this date, Your Lordship. Even when the recent impugn judgment on revision was passed, Your Lordship, even 30,000 has not been given for a single instances, Your Lordship. Now from 2017, Your Lordship will find that the child was in the nursery school, Your Lordship. Subsequently, when the enhancement was filed in the year 2022, Your Lordship, when the enhancements was filed, the child had reached to class 6, Your Lordship. Now, just introduce the respondent in this case, Your Lordship. The respondent first is a DRDA officer, Your Lordship, and is submitted by the Learned Council that her payment has been increased to 2 lakh is completely false, Your Lordship. First of all, these DRDA people does not have a pension pension after retirement, Your Lord. She'll be retiring after four years, Your Lord. Secondly, she has not claimed for any maintenance for herself, and the whatsoever the PPF amount that she got during her service, Your Lordship, she have built her own house for her child and for herself, not taking any financial support from the petitioner, Your Lord. Now, thirdly, Your Lordship will see the other the source of income that has been brought even on the record is that there is only 105 square meter building, Your Lordship, and that building was jointly built by both the parties, Your Lordship. Now that has the rent of that. We admit that the rent of that particular commercial building is being taken by us, and the rent till date is only 6,000. If Your Lordship will, if I may take Your Lordship to page number 29 of the petition, Your Lordship.
Yes.
At page number paragraph 3, Your Lordship, because we have not, we also did not dispute and we have not asked for those 10,000 lapses, Your Lordship, till date, because I have been taking care of my child. But when it was, when I had admitted my child to Darjeeling in the year 2022 and had sought financial assistance from the petitioner, he completely refused, and therefore we have filed this enhancement. If I may read, Your Lordship,
Hmm.
the case of the petitioner in brief is that this court on maintenance number so and so by its order dated so and so had awarded monthly maintenance for petitioner number so and so, an amount of rupees 10,000 per month, and also to pay the school admission fee of petitioner number 2. And when the order was passed, petitioner 2 was merely aged about 5 years and admitted to play school. However, petitioner number 1, however, no petitioner number 2 is grown up and is aged about 11 years and studying at class 6 as the maintenance allowance of 10,000 is insufficient to meet up the requirement of petitioner number 2 due to increase in inflation and higher education fee, petitioner number so and so. Now, if Your Lordship will come to paragraph 6, Your Lordship,
Page?
page 29, 30, 31, Your Lordship. There is an intimation letter, Your Lordship will find, which is also annexed along with this at page number 122, 121, that has been reflected at paragraph 6, Your Lordship.
Mhm.
If I may. Respondent had also taken plea that petitioner number 1, without consulting the respondent, had got petitioner number 2 admission in costly school beyond the capacity of the respondent, as respondent has to maintain his aging mother, ailing wife, 3 other children from his first wife, and also widow, sister-in-law, and nephew. However, despite financial constraint and compliance with the order of this court, has paid admission fee of rupees 3,50,000. Now, this was later on confirmed to be only 35,000, Your Lordship.
Hmm.
I'll take Your Lordship later on to that part, Your Lordship. From school paid earlier. This respondent has contended that cost of education of the petitioner number 2 should be at par with the earning capacity of the parent. Further, respondent has taken plea that apart from the monthly salary of 1,56,000, petitioner are getting extra income of 4,70,600 per month from rent from Jion. So these are the two only objection that they made is one that she's earning, and the second is that she's getting this much of an amount from the so-called commercial building. Now, to that effect, I would like to bring to your Lordship notice that when the child was in the Darjeeling for 2 years, Your Lordship, only one time 35,000 was paid. Rest of all the transportation, school, boarding, everything is being done by the mother here, Your Lordship. Since she could not financially keep her child to Darjeeling, who is a very brilliant student, Your Lordship, she had to then, for class 8, 9, and 10, she had to transfer her child to Gurukul boarding school in Tinsukia. And the per year of the child's cost, including the school fees, uniform, the hostel, tuition, everything, Your Lordship, it includes 3.3 lakhs, Your Lordship. Even to that effect, Your Lordship, she has been continuing with paying the entire educational fee and the other necessity of the child, Your Lordship. Now, if I may take Your Lordship to the revision, the judgment of the revisional court, Your Lordship. If Your Lordship come to page number 42, Your Lordship. Now, paragraph 6 has been read over by my friend here, Your Lordship. Paragraph 7, Your Lordship will find that the respondent never challenged the contention of the revisionist number 1 on her claim for spending major portion of her income on her health and her inability to maintain revisionist number 2 on account of spending major portion of her income on her health. Your Lordship will see page number 43, Your Lordship.
Yes.
Para 7. They had not made any objection to that effect that half of her income goes to taking care of for the maintenance of the child as well as for her health. Paragraph 8, Your Lordship, that the revisionist number 1 being working in a district rural development agency have no provision for pension after retirement, as her salary is governed on the basis of central provident fund, and as such revisionist number 1 herself does not have secure future, and on top of that maintenance and educating expenses of revisionist number 2 requires more than 40,000 per month. That the respondent never bore the education expenses of the revisionist number 2 except on 9/11/2022 when a sum of 35,000 only was paid by the respondent for education expenses. Now, Your Lordship will see from 2017 till this date, Your Lordship.
Hmm.
Even after the passing of the revision order,
Hmm.
he has not paid single education fees except for this 35,000 when he was in during the year to 2022, Your Lordship.
Hmm.
That was the only instances when she asked for the financial help from the petitioner hearing.
Hmm.
Now, paragraph number 9, if Your Lordship. The revisionist stated that it was never proved by the respondent before the learned court below that the respondent was maintaining his defendant. That the respondent have falsely claimed that beside maintaining revisionist number 2, he is maintaining other family members by spending huge amount monthly for expenses on food, medical expenses of himself and his wife, his mother for education expenses and other expenses associated with school-going children, wife of his deceased younger brother, and showed a monthly expenditure of 2,15,000 out of his monthly salary of 1,43,000. The revisionist submitted that upon maintaining more than 60 lakh bank balance, the respondent have stated in his reply that he has been serving for past 34 years and said balance into his account is the saving of him in 34 years of service and is maintained out of his hand hard-earned money to meet upon unforeseen expenses in urgency and protection his personal life during the age of post-retirement.
Hmm.
Paragraph 11, the annual income generated from the commercial building has been stated, Your Lordship.
Yes.
Now, that commercial plot, I'll just bring it to Your Lordship's attention at paragraph 13, Your Lordship, at page number 47. Now, that commercial building, Your Lordship will see that in her rejoinder, the revisionist has pleaded that during the year 2003, brother of respondent, namely so-and-so, borrowed a sum of rupees 2 lakh from revisionist number 1. That is her money, Your Lordship. And he could not return the said borrowed money to her. And hence, in the year 2006, he had offered her and respondent to take his commercial plot in lieu of the borrowed money. And as such, on that so-and-so, a gift deed was executed by so-and-so in favor of the so-and-so. Now, she was the one who has given the money to the brother of the the petitioner, Your Lordship, and that's where how the commercial building came, Your Lordship. And down below, Your Lordship will see 3, 4, 5, 6. If Your Lordship count from the 6th line, Your Lordship, it starts with debt in her rejoinder. From down below, if Your Lordship will count the 6th
Para?
para 13,
Third, huh?
13, Your Lordship.
130.
Page number 47, Your Lordship.
Yes, I'm on 13 only.
From down below, if Your Lordship count
That in her rejoinder.
yes,
Ah.
revisionist number 1 clarified that the said commercial building generate only rupees 6,000 per month, but since the condition of the building is deteriorating, as such, tenant does not stay in the said building on regular
Oh.
basis, and income from the said building is also not regular, Your Lordship.
Hmm.
If I may take Your Lordship to page number 48, paragraph 14, Your Lordship.
Hmm.
She does not owe any private or government plotted in her name, and she was the second wife to the respondent, and hence, even after her marriage to him, she never received any kind of movable or immovable property from the respondent, Your Lordship. Now, 17 is where the observation was made, Your Lordship. For that, the learned court below has erred in dismissing the enhanced petition in contrary to the law provided under section so-and-so. For that, the learned court failed to appreciate the fact that at the time of passing order so-and-so in maintenance, the revisionist number 2 was in play school and was a mere child of 5 years old only. Whereas at the time of filing of the miss case so-and-so, maintenance so-and-so, the revisionist was studying in class 6 and had attained the age of above 14 years and miserably failed to appreciate the fact of the change of the circumstances. For that, the learned court below has failed to appreciate the fact the respondent was not bearing the educational expenses of revisionist number 2 and wrongly passed judgment order dated so-and-so 23/11/2023.
Hmm.
So 18, 19 till all those submission as well as the records were taken into consideration while passing order for enhancement in this revision petition, Your Lordship. Now, Your Lordship will see that the child is already in class 9, Your Lordship, 10, Your Lordship.
Mhm.
He's already 15 years
10
of age.
standard. Hmm.
Yes, he's already 15
Hmm.
years of age, and Your Lordship will see that the respondent here has not sought any maintenance from her. from
Mhm.
from the petitioner, Your Lordship. In fact, her only concern was her child, since she is well aware that she has no future prospect in financial with regard to financial responsibility, Your Lordship. She's retiring in 4 years, Your Lordship. And also, Your Lordship will see that they have not been paying since date, Your Lordship.
The enhanced amount or the original amount?
Even the original amount, Your Lordship will
Then
see 2023,
I'll
even,
pass a direction then again.
yes. In the year 2025, when this revision was filed, Your Lordship, when the court had ordered on December of 2025, even till date, and as already submitted, Your Lordship, no education, except for the 35,000, no education investment has been done by the petitioner, Your Lordship. And Your Lordship will also see that since the record has not been called for, Your Lordship.
Yes, we'll call for it. And
Yes, just I have the record. I'll just the liabilities that they have stated before
Mm.
in their affidavit as well as in their affidavit of assets, Your Lordship.
Mm.
This was also discussed, and it was, Your Lordship will see his nephew, neither his sister-in-law is being dependent upon him.
Mm.
His wife is also an earning person
Mm.
who earns. She's an ST who earns more than I like, and also the son. They are already 36 years, 30 years. Only one daughter who is a minor, Your Lordship,
Mm.
of 15 years of age.
Mm.
My only prayer is that, Your Lordship, since Your Lordship will see, since I cannot be compromising on the study of my child, Your Lordship, I have already done it when I have put him to a better school. Only because of my financial constraint, I had to bring him back to and get him admitted to another school, Your Lordship. My expenses still date per annually only on his education is 3.3 lakhs, Your Lordship.
Mm.
The other saving that I put on for my husband, my son's future in the bank is also totally not put before this court, Your Lordship.
Okay. I think that's sufficient. And I will also take your submissions on that point, not in a complete manner, because that is reserved for the
Yes,
main hearing.
Yes, yes.
But your preliminary content submission on that point, that he has already submitted,
Yes,
that revisional court could not have substituted its view.
yes.
According to you, could it have?
It can, Your Lordship. I have certain judgments. If
Oh.
Your Lordship otherwise
Hmm.
take it as a last matter, I'll
Are
just
you-
produce
you-
some judgments
have?
to that
Because
effect, Your Lordship.
Otherwise, I'm telling you, otherwise, if that a question arises as to whether the revisional court can do that, then probably this court will be inclined to stay the matter for some time.
Yes, yes.
And stay the, because if it's a question of, error
Yes, Your Lordship.
as far as jurisdiction is concerned,
Yes.
then it has to be stayed.
Yes.
So should we pass the order today, or you
Uh,
want to
My lord.
show
Your
some
Lordship,
case
Your
law?
Lordship, I have certain judgments that I'll bring otherwise fixed on only for giving of the judgment for tomorrow also. I'm
Yes, I
ready.
think that will be better.
My lord, I have a judgment immediate regarding.
We'll see it together. Huh? Tomorrow we can. Tomorrow I have single bench. We can,
Yes.
because let's put our mind on that issue.
Yes, yes.
Because otherwise, if doubt persists, then it has to be stayed,
Yes.
perhaps. In any case, even if it is stayed, we'll quickly call for the records and finally hear and then.
Even-
There should not be delay in these matters.
Yes, even if that is
Otherwise,
stayed,
it will have no meaning, these
even
matters.
if that is stayed, at least the 10,000 that was
Oh, that has to be
that
done.
will have.
That I will give a direction, but you do look up a case law.
Yes.
Would you like it tomorrow or day after? Day after we have division bench again, or on Friday you would like,
Any date, Your Lordship, feel
Hmm.
convenient.
as per your convenience,
Tomorrow, Your
both
Lordship.
tomorrow. If you can.
And
arrange
also, my
that,
lord,
this thing.
if we may, my lord.
Stop. Heard Mr. Learned Counsel for the petitioner on the question of a stay of the impugned order dated 23/11/2023, passed by the revisional court 23/11/2023 in sorry. Sorry, 8/12. 8/12/2025 passed by the revisional court in criminal revision number 2 of 2024, whereby interfering with order dated order dated 16/5.
1812, my lord.
No, 18/12 is the impugned order, revisional order passed by the revisional court, where interfering with the interfering with the order
2311.
order dated 23/11/2023, rejecting the prayer of the prayer of the applicant for enhancement of the maintenance amount of 10,000 granted to the child of the parties, minor child of the parties, by order dated 16/5/2017, passed by the learned CJM in it's okay, no problem, in maintenance case number 4 of 2016. Good stuff.
Your Lordship, it's miss case number 73 of 2022 in maintenance case number.
No, the original order was passed in
Yeah.
4/16, which was enhanced in miss case, which was dismissed. The enhancement was dismissed in miss case 73 of 2022, right?
Yes, sir.
I will check it, okay? Full stop. In support of the support of his prayer for stay of the impugn order passed by the revisional court, the learned counsel for the petitioner submits that apart from the enhancement being not justified in the facts and circumstances projected from the side of the petitioner, the order is also erroneous in as much as the revisional court substituted its own view and granted the enhancement of the maintenance. Full stop. It is also submitted that during the proceeding, the petitioner had placed materials before the court regarding his numerous financial liabilities, despite getting a reasonable amount as salary. Full stop. On the other hand, Ms. Jeannie, learned counsel, appearing for the respondent wife, submits that the revisional court was not in error in delving into the matter and enhancing the maintenance to rupees 30,000 per month, keeping in mind the elapse of time and the current expenses that the current expenses that have to be incurred on the growing up child by his mother. Full stop. The learned counsel, Ms. Jeannie, also submits that the respondent had also placed materials before the court about her medical expenses on account of some cardiac ailments. Full stop. On the next paragraph, on the aspect of whether the revisional court whether it was permissible on the part of the revisional court to enhance the amount while adjudicating the correctness or otherwise of the dismissal of the petition seeking enhancement. It is submitted that the some case laws would be placed before this court, and the learned counsel seeks some time for the same. Therefore, the hearing remains inconclusive on the aspect of interim order / stay remains inconclusive. The learned counsels may submit their respective judgments. List tomorrow.
My lord, I have one submission, my lord. My lord, in regards to the government that we have not been paying the maintenance. So my lord, as the person is not in station, he is at Namsai. So we won't be able to file an additional affidavit. But however, can we be allowed to place before the honorable court the payments made till date
Okay.
without an additional
So
affidavit?
I'll have a look at it.
We'll file it.
Otherwise, you clear the areas.
Yes.
You clear the areas.
Also, Your Lordship,
Because if tomorrow it may not be possible to file the additional affidavit
Yes.
because he's not here.
Can we That's
You
why
bring the
I-
materials.
I have just spoken yesterday, Your Lordship, like the mediation I had suggested even yesterday, Your Lordship. It seems even the revision court had called up the party for mediation, Your Lordship. It
Hmm.
was never successful.
That would have been best fun anyway.
Yes.
You cannot force people also.
My lord,
Thank you.
Let's,
also the interim.
yes,
prayer-
the interim order stands extended. Interim order granted by order dated yesterday. right?
Yesterday.
Here the order dated 3/8 stands extended till the next date of list.
Much,
We'll take it up tomorrow if necessary in the second half.
much.
Item number 11,
Orders can also leftover matter to review.
May I please, Your Honor?
Yes. Why it has come up for?
Madam, for disposal, madam. Madam, in Lordship's, this short duration, madam, such type of cases has come up and Lordship has taken, madam, the exhaustive hearing in similarly situated cases. Madam, this is a case where, madam, the power and the jurisdiction has been wrongly exercised by the, madam, the other authorities, not by the village authorities, madam. So, madam, if, madam, hopefully, madam, my learned friend will not object if the disposal is made by setting aside the impugn order, madam, issued by the, madam, different authorities, madam. And the period short for herein the, madam, basically,
Now, do we have the records? Do we have any
no,
records?
records is not called for, madam.
Records, won't it be necessary?
Yes, madam.
Hmm?
Even they have not also filed, madam, the affidavit also, madam. Even, madam, when the, madam, my
What,
friend
on,
proposed to, madam, consider the,
On
madam,
admission,
submissions
madam.
to be made by, madam,
On admission.
the petitioner.
Yeah.
Madam, in that case, madam,
What
even
is- yes,
records
ma'am.
may not be required, madam.
okay.
My lord, actually what happened is,
What is your instruction?
my lord, here, no doubt, the complaint has been filed in different jurisdiction, my lord.
Hmm.
So there is a jurisdiction error.
Mm.
So I would like to concede with the application, and the same may be disposed on the ground that there has been jurisdiction error, my lord.
Okay.
And accordingly, we will be filing in a proper forum.
Okay. So it was okay, then let me
Madam.
go
Madam,
into,
may I just sum up
the
the,
impugn order is at
madam,
page
20.
28.
yes,
Yes,
madam,
my lord.
Page 28, this was issued by Inter-Village Territorial Customary Court.
who has no jurisdiction, madam.
My lord, they would, he is from Model Village, my lord.
Okay.
So
The complainant is,
they are from Borum, UP, my lord.
Madam, may I-
So the complaint ought to have been filed in Borum, UP.
if that is on that point, limited point, it can be disposed of then. Yeah, make your submissions.
madam, only the barrier is, madam, both, madam, the respondent and the petitioners are, madam, the real brother and sister, madam, the out of same parents, madam. And, madam, there was admittedly, madam, the property disputes, which was amicably settled between the parties, madam, by a deed of agreement. Lordship will find it, page number 18
Mm.
of CRP, madam.
Mm.
Page number 18, Annexure 1, madam.
Mm.
This is the agreement, madam, the amicable settlement made between the parties,
Mm.
wherein, madam, the petition respondent has also happily agreed
Mm.
and accepted the, madam, property disputed, madam, distributed by the, madam, the senior village members and the other, madam. There is no, madam, any hesitation on this subject matter. And thereafter, my lord, despite this agreement, my lord, Lordship will find it,
Yes,
page number
Despite this agreement, the complaint came to be filed.
yes, madam.
Mm.
And not only this, on 26th, my lord, April 2021, my lord, long year back, my lord, this has been, my lord, settled between the parties, my lord.
Okay. It was settled in 2021,
21.
April. Then the complaint, where is the complaint?
My lord, then thereafter, my lord, what happened, even after this settlement,
Uh,
my lord, the sole respondent herein, who is my brother, my lord, real brother, my lord. My lord, making, my lord, the notions and the, my lord, creating,
With all the more reason that it should be settled amicably before the customary court.
my lord, this has been already settled.
Uh,
This is the, my lord, I points, just, my lord, I wanted to, bring your lordship.
Already settled once.
Settle one, my lord.
Okay.
And, my lord, after settlement, we are, my lord, in the respective place and the respective plot of land, my lord.
Mhm.
There is no dispute.
Mhm.
But, my lord, surprisingly, by, my lord, the complaint dated, my lord, undated, the page number, Lordship will find it, page number 29, my lord.
29.
Annexure 4.
What
This
is
is the complaint, my lord.
date is not there?
My lord.
What is the date of the complaint? Date.
No date, my lord.
No
Nothing has
date.
been given, my lord. It is the
There must
document
be.
furnished to me by the village authority. My lord, Pursuant to this notice, the complaint, Lordship will find at page number 29, wherein the address is given to the President, Itanagar Capital Region, Gauhati Association, which who has no jurisdiction, And pursuant to this,
And it was taken up by this inter-district customary court.
Inter-village territorial customary code, page number 28.
Hmm.
This is the impugn summon
Hmm.
issued to me,
Hmm.
This is also jurisdictional error, is because such authority cannot issue this summon. Basically, I am agree by
Okay.
this summon.
She is also agreed. So
Yes.
dispose it
So
off.
therefore, Lordship may kindly observe one thing,
Hmm.
This amicably, it has already been settled.
Hmm.
So therefore, the jurisdiction, there is also jurisdictional error, To that extent, matter may be set aside and quashed.
Set aside, and if you want to still, have some grievance, you can ventilate it before the appropriate customary court.
My lord, I have one request, my lord, here. Since here they have come with the jurisdiction error, my lord. So at this stage, my lord, the decision of this settlement of the matter may not be entertained, because this is not subject to the lower court, my lord, in fact.
Oh, yeah, that will be decided by the appropriate
Yes,
customary court.
yes, my lord.
However, kindly one observe, observe one thing, that settlement, regarding settlement, that has already been made.
It is of annexed also.
Yes, that, but to that extent,
No, heard, have a seat, no, sit down. Heard, learned counsel for the petitioners and respondent, full stop. The petitioner, Miss Nabam Ripomi,
Right.
has invoked the jurisdiction of this court under Article 227 of the Constitution of India, read with Section 115 of the Civil Procedure Code 1908, for setting aside and quashing the summons dated 17/6/2026 issued by a customary court, being the where is the notice page?
Page number 29. 28 is the notice, summon. Page number 28, Annex 3,
Yes. Summons dated 17/6 issued by the Inter-Village Territorial Customary Court
Madam.
of Itanagar Capital Region. Full stop. Directing the petitioner to appear before the customary court, said customary court on 26/6/2026. This is over already.
Madam.
This is over already. Full stop. Next paragraph. The said summons was issued on the basis of a complaint made by the respondent against the petitioner with the allegation of her taking away his movable and immovable properties and selling it to third persons, and request therefore to settle the same by holding a mail under the customary law. Full stop. Next paragraph. Thus that the petitioner and the respondent are brother and sister by blood, and that a dispute between them over the property was earlier settled, amicably settled on
Page 18, madam. And
page
18, madam. Annex 1.
on 80,
26.
on 26/4/2021. And with regard to the same, a deed of agreement dated 26/4/2021 was also executed between them. Full stop. This agreement took place in the presence of these 22 persons were witnesses, in the presence of 22 persons
Madam.
during the mail. Full stop. Next paragraph. However, despite the said settlement, the the respondent filed the aforementioned complaint within bracket undated, whereupon the inter-district customary court issued summons to the petitioner, comma, leading him to file this revision. Full stop. What is your area, resident?
Model village.
My lord, it is
both-
The petitioner is stated to be a resident of
Borum Bill.
Barum village in the Papumpare district of the state. And the respondent is also stated to be a resident of the said Barum village of Papumpare district. Full stop. Next paragraph. Learned counsel appearing for the respondent fairly submits that the the inter-village territorial customary court would not have jurisdiction over the matter, as both the petitioner and the respondent belong to the same village.
My lord, I would like to mention here, my lord, though it's a capital complex, my lord, but it's from model village. Model village.
Model village.
The Gamburas are from model village. They all.
Okay. And same village being Borum village, and that both the petitioner and the respondent would be subject to the jurisdiction of the customary court by way of Gauhati model village.
No, my lord.
No.
The complaint was
Mhm.
filed in model village to the Gamburas of model.
Model village.
Yes, my lord.
Okay.
So the complaint ought to have filed in the
In this way.
to the Gamburas of Borum village.
Right, right. Post. Sorry, we cut that line. We stop. It is submitted by the learned counsel for the respondent, and that the complaint by the respondent was filed before the Gauhati of model village, whereas it should have been filed before the Gauhati / customary authority of the Barum village of Papumpare district, of which the petitioner and the respondent are residents, right? Full stop. But even then, they referred it to the inter village, which is a higher authority. And that even as an original authority, it may have jurisdiction if the persons belong to different villages. It is submitted that to that extent, the summons issued to the petitioner by the inter-village customary court suffers from an error of jurisdiction and can be interfered with. Full stop. Next, in the aforesaid facts and circumstances, as both the petitioner and the respondent have agreed that the summons, the impugned summons suffers from a jurisdictional error. It is prayed by the learned counsel that the matter may be disposed of at this stage by passing suitable orders. Full stop. Next paragraph. I have perused the relevant materials and considered the aforesaid submissions. In the facts and circumstances and in the backdrop of the aforesaid submissions of the learned counsels on both the sides, the summons dated 17/6/2026 issued from the Inter-Village Territorial Customary Court of Itanagar Capital Region is hereby set aside on account of a jurisdictional error. Full stop. Thus, the criminal revision stands allowed and disposed of on the aforesaid terms. However, yes,
Sorry, my lord, can a line be added that
yes, that's why.
we would file in appropriate
No, my
forum, my
lord,
lord?
that I'm objected to, my lord.
Why?
Once it is, my lord, set aside, my lord, the often, my lord, the next course of actions will always open today, my lord. It is
Uh,
not required
no.
to be mentioned, my lord. I'm, my lord.
The parties are at liberty to.
My lord, I'm sorry,
settle-
my lord, that if liberty is given, my lord, that will be again, my lord, prejudice me, my lord.
No,
My
because
lord, my lord,
liberty
the
is.
option available to them, my lord, there is no barrier as such, my lord, from the other side. So therefore, when he sees considering the, my lord, the barrier which I
Learned
sought
counsel
for,
the respondent submits that. Learned counsel for the respondent submits that he may be given the liberty to ventilate his grievances, if any, before the appropriate customary court, if so advised. Full stop. Next paragraph. As the dispute between the parties who are siblings have already been settled once
my lord,
in April 2020,
Yes.
21, comma. And if some further disputes still persist, they are at liberty to amicably settle the same. And if need be, take recourse to the appropriate customary court forum having jurisdiction. That's
my lord, I'm very sorry, my lord. I'm prepared to make submission, my lord. If such observation is given, my lord, otherwise again, it will be prejudice to me, my lord.
No, but.
How-
There is no, my lord, there is no barrier just from the
that
other
is
part.
why she made the submission.
Yes.
That is why she made that.
No, my
submission.
lord, otherwise, my lord, that option is always available to them, my lord, even without mentioning, my lord.
In
No,
that-
then otherwise, then you will go to, then you'll show that this has been dismissed once, so
Yes,
they cannot file.
no, my lord, that part is also not, my lord, there, my lord. Other, my lord, the option available, my lord, the remedies available, that cannot be, my lord, the clause.
You just write like this, the parties are at liberty, don't cut it, just keep it, but I will add and check it later. The parties are at liberty to settle their disputes if any in an amicable manner.
My lord, in that case, my lord, they have put a document here saying that the matter has been amicably settled.
They-
We don't know
Are you-
if
are
that
you
matter,
disputing- Maria-
no, I'm not disputing.
Then we'll
because-
have to take it to hearing.
Yes,
madam.
that's
Then
the
in that
reason,
case, my lord,
because
let
he's
the matter may
objecting in
be-
Don't
everything.
take the court for a ride like that.
Yes,
Once
madam.
you said you agree, then
Yes,
you make your submission.
My lord,
No, I will not disagree with you. You make that whatever I've written like that. There is
one hand, my
liberty to
lord,
invoke the
is
customary.
my lord, considering the my barrier.
See, the record is not here.
Yes,
Yes.
See, we are disposing only on her submission.
Yes, my lord, I'm.
Now, after she has made the submission, now you want to tailor-made the order to your benefit.
no, my lord, no, my lord. If she is considered the my lord barrier which I sought for, my lord, not more than beyond that, my lord.
She is always at liberty.
My lord,
See, the thing is that
my
are
lord,
you-
it is not me, my lord,
see,
where
are you-
I am making my lord the
No, no,
submission on
no,
my
no.
lord, other aspect.
No. Are you challenging? Are you challenging the merit of the order that she has no right? There's no right to challenge.
My
You're
lord,
not challenging that.
my
That
lord-
we are no. You are challenging that. We are not going into that. We are only setting it aside that that this particular forum does not have jurisdiction.
That's it, my lord. Therefore, my
That's
lord, this is the my objection, my lord, not beyond that, my lord.
She is always at liberty to ventilate the
My lord, that
grievance before
liberty,
the
my lord,
appropriate.
if that liberty will be again, my lord, the
Then what
prejudice
will
to me, my
happen?
lord.
Then what will happen?
My lord, therefore, my lord, my barrier, my lord,
No.
respectful
Then what will
once,
happen?
my lord, once he is conceding the my lord, the
No,
barrier.
then what will happen? She will file the petition before the appropriate customary court. Can you prevent that in law? You cannot
And
prevent.
that same way, my lord, if even if it is liberty is not granted, my lord, that will not, my
She
lord,
will not be able to file. Then
no, my lord, that
if
will be
li-
not there.
no, no. Are you saying that if liberty?
I am making submission on the, my lord, the merit of the case, my lord.
No. I disagree with this. It's disposed of on these lines only. You file it if you want, and best is you see. I have also settled. You settle it amicably within yourself. Don't go to customary court also. You settle it if there is a further dispute.
My lord has already observed one.
Already observed.
Yes, my lord.
I have observed that in the
That
past.
settlement has already.
Yeah, no, already
Well,
been settled.
yes,
If some further grievances, disputes remain,
Yes.
they are at liberty to settle it amicably, including approaching customary jurisdictional customary court. That's an option. That is an option.
Item number 12.
That's okay. You're unnecessarily worrying. No,
I'm sorry, my lord.
no. No problem. Don't bother. It's okay. So don't say sorry. I'm saying that you are needlessly worried. That is there in all litigation. That option is always, the disputes are there. Any dispute can be settled by ADR.
Madam, may kindly appreciate one thing. One hand, Mala, she is considering my area.
Hmm.
And the other hand, she is making the another condition there.
No, she is considering the lack of jurisdiction, not the merit. You know, best is you settle it amicably outside court, outside customary forum also. Don't go to customary forum also. That is the last option.
Well.
Okay,
Deep problem.
nothing to worry.
It is your lordship.
Yeah,
In
leftover
this-
matter.
In this matter, the office note dated 16/7, 2026 says notice has not been served in respect of R2, return of service. Oh, you are appearing? Okay.
My lord, today I filed my Bakalat Nama.
Okay, it's a for quashing of FIR.
Yes.
Okay.
I am for the respondent number 2.
Lordship, we are yet to submit case study, Lordship, which is, we could not submit today.
Case diary?
Yes, Lordship, case study.
Okay.
Your Lordship, I'm appearing on behalf of the respondent number 4, Lordship, the state of Assam.
No, my lord.
Item 12.
My learned friend is in another matter. My learned friend is appearing in item number 4. This is item 12, my lord.
I'm sorry, Your Lordships.
Okay, just a minute. We are taking up item.
Item 12.
What?
No, she is appearing in item 4. Maybe she saw me, that's why she appeared, my lord.
Left, timing was which matter?
Time being was item 4.
Item 4. Oh. Just hold on, huh? I'll just check in. This has come up for orders.
For orders, my lord.
PD Nair, learned counsel for the petitioner. L. Hage, learned additional PP, and good name, please. For the learned counsel has entered appearance for the respondent number 2, who was the informant.
Yes.
Informant of the case, full stop. In this proceeding, the petitioner is seeking quashing of
FIR.
Itanagar PS case number 276 of 2020 under section 420 IPC, which was registered based on an FIR dated 25/11/2020. Full stop. Ms. Hage, learned additional PP submits that the scanned case diary is not received today and seek some time for the same.
Short period, Lordship, short test.
You filed a Kotalama.
Yes.
Will you file any written?
Yes, Your Honor. I need some time to file.
The learned counsel for the informants seek some time to file an affidavit in opposition. Prayer is allowed, and we'll work out a day. You can appear online also.
Mine.
List on
Next week, Lordship, any day.
towards the end of next week.
Yes, Lordship.
Huh?
14, my lord. Or
Yeah,
no,
14
my
will be
lord,
not bad.
Like,
deeply obliged.
No problem.
Item number 4, passover matter.
May it please your lordship. Lordship, this is a proceeding, my lord, for quashment of FIR and charges, my lord.
Madam was appearing online
Yes.
on this matter.
Yes, my lord. Yes,
Please
Ms.
assist you.
Devi is
Yes,
appearing in
Lordship.
this.
No, I can hear you.
My lord. My lord, and quashing of the charge sheet as well. My lord, in this case, my lord, I was at that point of time an circle officer discharging my duties as an executive magistrate in an eviction drive which was carried out in Singlijan Reserve Forest. I was in the circle officer of Helem Revenue Circle. My lord, during that eviction drive, some houses were constructed in Singlijan Reserve Forest, which is within the territorial boundary of Assam. When the houses were demolished, an FIR came to be filed, my lord, after that, on 5th of October, 5th of April 2008. This FIR is at page 36, my lord.
Do we have the records, Ms. Hage?
Yes.
Do we have the records?
file our affidavit, Lordship.
Huh?
Affidavit we have filed, Lordship.
You file your affidavit.
Affidavit is there.
And because the records may be necessary, right?
Maybe
CD.
I have no records, Lordship.
My lord,
Only
it's,
affidavit we have.
charge sheet has already been laid, my lord.
No, because we have to see the case diary as well as the charge sheet to
Lordship,
adjudicate the
charge
issue of
already
quashing.
filed. Charge sheet already.
Charge sheet I have
Charge sheet
filed
and
the-
case diary also. We'll need the case diary also. You have the case diary?
No, Lordship.
Don't have the case diary.
No, Lordship.
The charge sheet is there on record, my lord.
But the case diary will be necessary
My lord,
to determine whether the finding of the charge sheet is correct.
my lord,
And the
my
case diary will be
my
necessary.
lord. I have annexed the statements also
Oh, okay.
appended to the charge sheet. And in fact, my lord, in a similar proceeding,
Mm.
it has been quashed earlier by a coordinate
That
bench.
will take it up. So let us call for the case from the, it is pending before magistrate
Because,
UPR, my lord.
UPL Lordship.
within a week.
CGM UPR.
We can, fix-
GMFC UPR.
we can fix it on the same date as
My
the
lord,
bail.
on 11th, my lord, next
yes.
Tuesday, my lord.
Tuesday will the CD come? CD?
Lordship,
The earlier
the
matter.
record Lordship may be called for from the court Lordship because they
Good stop.
charge sheet already
Third-
been filed Lordship.
To deny, and I'll counsel for the petitioner. And Hage. There are a couple of private respondents.
My lord, they have never entered appearance, though,
They
my lord,
they were noticed.
they were noticed even through the police. There is some
Okay.
order.
You are appearing for?
Respondent for the
I am
chief
appearing for the
secretary.
respondent number 4, 6, and 7 for the state of Assam, Lordships.
4, 6, and 7.
And I have already filed my affidavit, Lordship.
You filed your affidavit.
My lord,
Okay.
Assam government has
Lordship.
filed, Forest Department has also filed,
Fine.
and state of Arunachal Pradesh has also.
All have filed
All
except
have.
2 and 3.
2 and 3, they have never entered appearance, my
Okay,
lord.
but they were served.
They were served even through the police intimation work.
Okay.
Even. That is why
Uh,
it has been pending.
It
for
is submitted by Mr. Nair that except respondent number 2 and 3, all the other respondents have entered appearance, have filed their pleading as well. Full stop. It is further submitted that respondent number 2 and 3 had never entered appearance, though they were duly served. Full stop. The next paragraph, the petitioner is seeking quashing of GR number 1 of 2008 pertaining to Balijan PS case number 10 of 2008 and the charge sheet number 9 of 2010 dated 3/11/2010 under so and so sections. Page 2, 341, 427, 448, 395, 34 IPC. Full stop. It appears that the scan TCR is not yet available. Accordingly, call for the scan TCR of GR number so and so from the Court of the Learned GMFC UPR, comprising the scan copies of the case diary, charge sheet, and other relevant documents. Only these two we need. Full stop. Though you have annexed, but better to see the official documents once. So,
My lord, about the whether they have been served or not, my lord, there's an office note of 21st
Yes.
January 20.
don't worry, I'll check
My
it once. I'll check
But
it.
it was steps were taken through the police, my lord, through registered post as well. 24th January 2023 it is typed, but it should be 2024.
Mhm.
And return service in respect of the private respondents, they have most probably not come, my lord.
2 and 3.
2 and 3, my lord. But they were taken through the OC Balijan PS as well.
Any feedback from your side? Have they been served?
Lordship,
2 and 3.
Lordship, we have to check Lordship because Lordship, they are private party Lordship.
Learned Council also enters appearance online mode for respond number.
4, 6,
For
and 7.
respondent numbers 4, 6, and 7.
4, 6, and 7. And submits that they have also filed their affidavit in opposition. So this part we'll have to cross check, huh?
My
Respond
lord,
number 2 and 3.
my lord, but
Who are 2 and 3?
The
Lordship, they are informant Lordship, they are private party. Their name,
I see.
by name they are Lordship. respectively.
Informant. They will be essential,
no, my lord, they are not required otherwise because
not a POXO case.
it's not a box. Everything is on charge sheet has been filed,
Nah, still, since you have implemented them,
my lord. But a lot of times,
good of you to implement them, but let us see. The pertinent office notes are not indicative, it seems.
to officer in charge Balijan was taken. It was taken.
Only service is necessary. They don't have to appear.
My lord, service was.
Since you have implemented, only serve.
My lord, Office Note 24 January 2024, but it is type 23. And memo number is 253 to 55, my lord, dated 24/1/2024. Yes, through OC Balijan, yes.
Yes, 21, 24, 1, 23,
But it should be 24, my
24, 24, 20.
January, my lord. Sometimes it happens,
Mhm. It's not clear whether it is served or not.
my lord. But it has been effected through the OC.
Then you write a line, cut that, I'll cut that, I'll insert it later. That in terms of office note dated 24/1/2024, steps upon respond number 2 and 3 were sent on 24 on the said date through the office of the OC Balijan PS. So thereafter, it's not clear whether
It's
it's
not clear.
We can proceed,
Yes, my lord.
proceed with the
Yes,
matter,
yes, my lord.
even if they are not
The
served.
statement must be there in the record,
The
Lordship.
statements are there.
No, I'm saying that not today.
Or
I mean,
to-
we'll call for the records, but
Yes.
even if 2 and 3 are not served, we can proceed with the matter.
Lordship, because already Lordship, they have taken a step, Lordship, but
Yeah.
they are not appearing, Lordship.
Must have been served.
Yes,
My-
Lordship.
Anyway.
Actually a border dispute matter, that's why. my lord.
Comprising other relevant documents. Okay, scan record. List on, you take the date now.
11th, my lord.
This judgment you have submitted.
Earlier it must have been submitted, my
11th, 11/8.
deeply obliged.
So
my
like,
Obliged,
Matter
your
number
Lordships.
13.
Item number. 1, 3. Yes,
My lord, on last occasion, CD was called for, my lord. This is joint petition, my lord, for quashing, my lord. Offense is POXCO, my lord.
Your Lordship, remember this, I had made a preliminary objection with regard that one of the petitioner is still a minor, Your Lordship.
okay. I have just perused the last order. This is the case diary.
Yes, Your Lordship.
The case is at the stage of
Investigation.
investigation.
The investigation is pending only with regard to expect, Your Lordship. One is that since the age of the victim was contradictory, Your Lordship, so they have requested for forming a committee for ossification, Your Lordship.
Yes. And that's not complete.
Not complete. It has, the board has also not been constituted till date, Your Lordship. Only a prayer has been made, Your
I
Lordship.
see.
And the second is that the
Yes. Go ahead.
yes, sir. And the second is for the FSL report, Your Lordship, which is yet to be received by the investigator.
FSL is pending and the ossification
Board is yet
test
to
is
be
pending. Board is not yet constituted.
only on these two aspects. Otherwise, the investigation has been completed, Your Lordship. Now, the contradictory part that has been shown in the CD is one is that the father has, I have flag marked it, Your Lordship. The father has stated that he had enhanced the age of the victim for her higher studies, Your Lordship.
It should have been,
There is
someone on our behalf actually should have become the petitioner
yes, Your Lordship.
instead of going into this dispute.
I was also, there is also, the CD also shows that at that point of time when the FIR was given, both of them were not married, Your Lordship. So it has to be a certain if both of them are married till date. If
Hmm.
they have got married, Your Lordship, as per the agreement, Your Lordship, and the age. Other than that, Your Lordship, I don't have any issues if she is a major and both of them are married.
If she's a major, then it's okay. But anyway, are we in a position to dispose it off?
Yes, Your Lordship.
Because some facts are still hazy.
Mm.
This too, as pointed out,
Yes, yes,
the age aspect is still under investigation.
my lord.
Ossification test is still to come, and the FSL is still not
Awaited, Your Lordship.
awaited. Its FSL is awaited, and ossification remains to be done after constitution of the board.
But my lord.
Or should we keep this pending and await the completion of investigation?
That can also be done, Your Lordship. I'm not as a,
Then suppose, as you had pointed out, that suppose the investigation is completed and this ossification finds her to be a major,
yes, Your Lordship.
then the matter will take a different complexion.
Yes.
It may be helpful for him also then. But at this stage, now we have to go by the FIR. When the FIR, from the FIR and the other materials as of now,
Yes.
the age of the alleged victim seems to be a disputed fact,
Because the document was
subject to investigation.
yes, because the document were given was of the birth certificate from the school, Your Lordship,
Hmm.
and the other was the Aadhaar card and the statement of the father, Your Lordship.
Hmm.
It's when since there was contradictory to that effect, Your Lordship, so ossification, prayer for ossification was made.
If you are seeking disposal at this stage, then you can submit. Otherwise, if you want to keep it pending for some time, you can keep it for pending for some time.
My lord, this is my humble submission is, my lord. This age of the victim, the petition number 1, is disputed, of course, my lord. As because, my lord, as submitted by the PP, my lord, the parameter stated that they have intentionally reduced the age of the victim while school admission, my lord. So, my lord, of course, that fact is there, my lord. That is disputed fact. Here, my lord, I'm before my lords for the my lord joint petition. This is joint petition for the joint petition for the my lord. Since both are now happily married couple, my lord. So, my lord, for that purpose, my lord, because since victim is already is married to the my lord accused person, my lord. So if trial will goes on, my lord, only my lord, the victim and accused will separate, my lord. So as per my lord, and moreover, my lord, in the FIR, my lord, this victim is clearly stated that, my lord, it queries the FIR, my lord. In the FIR, the victim has clearly stated that this accused person is her husband, my lord. That is in the content of the FIR, my lord. So, my lord, meaning they were already husband and wife. Out of some pipe, the wife has lodged an FIR against their husband, my lord. That is the case, my lord. And, my lord,
Small submission, Your Lordship. Otherwise, her date of birth is shown to be 7/9/2008, Your Lordship. This is August by next
September.
month,
7/9/2008.
8. Yes.
And the date of the alleged incident?
Is of
FIR?
6 June 2026.
6 June 2026.
By September, she'll be already 18 years. Now she is 7,
This birth 7/9/2008 is on the basis of
the birth certificate.
birth certificate.
School admission birth certificate.
Birth certificate.
School admission certificate, my lord.
So, yeah.
Yes.
6/6/2026, the alleged incident.
That's the
2026.
date of the FIR, sorry, Your Lordship.
Date of the FIR.
Yes, Your Lordship.
Let us see the FIR first once.
FIR is in my petition on page number 15, my lord. 15. 7/6/2026, 7/6/2026. In the contempt FIR, my lord, so read, my lord. It clearly stated.
Yam to here. Rajni Gyam.
Page number 50.
Rajni Gyam.
Yes.
But as you know, quashing an FIR has its own challenges,
Yes.
right? You have to go on the face of it. If offense is made out, then it's
Yes.
difficult to
Yes.
quash an FIR.
Yes.
Once a investigation is completed and charge sheet is submitted, then you have a more complete picture. It is then you can take a view as to whether
Yes.
what materials are there, not there. As far as this matter is concerned, at this stage, its age is still in doubt, actually, and we cannot really at this stage. What do you say, Ms. Jin? Additional the prosecution
Yes,
that at this stage of investigation, we cannot really overlook the birth certificate,
But
just like that.
that's the only
On the face of it, we have to go by that, and going by that, she is minor by a few months,
absolutely not.
3
Minor by
months.
1 month.
3 months, kind of, approximately 6/6, and then 7/9. 7/9, yes. 17 months, 17 years, 11 months and months.
In fact, if this was not an issue, I would not have.
2-3 months short. So
And
that
my lord, of course, my lord, if we go with the my lord FIR, my lord, offense, there is prima facie offense is being made of, my lord.
yes.
But after all, my lord, here we are before, my lord, on the basis of compromise, my lord. That we.
No, sir, please understand. If the was of a different kind, and the informant was not a projected minor, then things would have been very different. Then it would have been a normal case where the petitioner and the accused and the informant joined together to seek quashing. It would have been one of those cases. But here, apart from, I'm not even going into these sections. Apart from these sections which are there of POCSO, the minority of the girl and stage of the case, stage of investigation. So that is why. Anyway, but if you insist, let us proceed. So let us see the FIR.
FIR is, my lord,
We
page
can,
15, my lord.
I can go through the FIR.
15 of my petition, my lord.
Yes.
This is 15, my lord.
एक महीना रुकने से तो she becomes that's stage.
He is also stated to be 19 years.
Yes.
19 years. They're almost, age is almost in the contemporary, my lord. My lord, FIR is page number 15, my lord.
All right. This is the FIR. Yes. Yes.
My lord, have perused the FIR, my lord. In the
Then-
FIR,
Then the agreement.
agreement is page number, my lord, 18, my lord. 17 and 18, my lord. 17 and 18, my lord.
28-7.
Yes, madam.
Okay, yes, it was submitted before the IO also. These are the materials. These are the submissions from your side.
My lord, I actually have
Anything else?
brought some judgment to various
No,
high court
yes.
where it is held that, my lord, out of if the settlement is arrived between the parties after being married, my lord, though POXPO is attracted, but it can still be passed, my lord. But otherwise, my lord, at this I would like to withdraw, my lord. Liberty may be granted to me.
Yeah, you are, I am. Yeah, I take your submissions. We have already submitted.
Yes,
These
Your
are
Lordship.
submissions.
My submission is as per the CD, Your Lordship. The age still till date matters, Your Lordship.
Yeah, it
In
matters.
fact, I would have suggested, Your Lordship, like all
Yeah.
the judgments states
No.
that
No, there are some impediments.
Yes.
Firstly, POXO.
yes,
And her FIR is very incriminating.
yes. Also,
Lot of allegations. And she has alleged about being abused from 14 years.
yes.
I cannot hear him. Sir.
It's not audible.
It's not audible. You're not audible, sir. Can you just, we'll just check it from this end.
Sir, not audible.
Santosh. Icon? Oh, ঠিক আছে। মানে আর কালি করবো বলে। Okay. Kindly check the audio.
In fact, my lordship, I'm representing the victim.
Oh.
Since they are challenging the FIR and the charge sheet, lordship, definitely it will take some time. Time is also running up.
What is the stage of the case now?
Stage lordship, someone were
Now I can hear you. Now I can hear you, Mr. Prakash.
yes, lordship, whether I'm audio.
Now I'm hearing you. Let us see the quality of the audio. You speak.
My lord, this matter has come for quashment of the entire trial and charge sheet and trial. So today's time is too short. So may I, my lord, make a prayer? The lordship may kindly fix the matter in the month of September. August I may have some problem. So that lordship, because there is a stay order.
Is the stay order.
Otherwise, lordship, there's someone was issued to the accused person for SCC stage. But instead of they appearing before the CC, they have filed for quashing. There is materials also on the merit, if my lordship see the merit of the case. But lordship, 23,
Huh?
since 23, this matter has.
Yes, sir. 23 matters.
Also serious in nature, lordship.
Can you take a date in August?
Yeah.
No, after 15th August. Huh? It will be your learned colleague is appearing for the respondent is suggesting a date in August. So you can take a date in August, 3rd or 4th week.
August, I will go for medical checkup. That's why, my lord.
What kind of stay? Further proceedings.
Yes, Lord.
Last week of August, are you agreeable to last week of August? 24 to 27? 24 to
Any
28?
date? My lord, may I just suggest, my lord, if otherwise convenient, my lord, any date, my lord, beginning from 7th of September. Possibly by that time I will be able to come back.
7th of September. Okay.
7th is a Sunday also.
No,
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 any date.
no. It's a
Monday,
Monday.
Monday.
It's a Monday. Okay.
It's too long, Lordship. August, it's just starting.
Yeah, I would have, yeah, I wanted to fix it in August is started now, right? So about a month. About a month.
Right.
About, I would have been happier with a date in the last week of August or
Yes, Lord.
even third
Only
week would have
problem is
been
that, my lord,
best.
I shall have
Is,
to renew if I don't able to
There's
come.
some medical issue.
Yes.
SD Purcaster Learned Council.
Make a podcast.
AK Purcaster Learned Council appearing online from Gauhati. Submit that the matter the hearing of the matter might take some time. And perhaps it may be taken on another date. In this context, the Learned Council submits that as he has some issues pertaining to medical checkup in the month of August. He prays for fixing the matter in the first week of September. Immediately in the first week of September, can we
My
fix
lord,
it?
any date on 8th. Lordship may fix the matter on 8th. No, Lordship. Lord, or my lord, 9th of September. They are going, Lordship.
No,
Or
yeah,
on 7th of September. 7th of September, no problem. May I be afraid that on 7th September, if my lordship allows, then better maybe an endeavor shall be made for disposal. Yes,
If fail, it's for hearing.
Then interim has to be vacated, lordship.
It has
No,
for, it's for
matter has
hearing.
come for hearing. Why you are insisting? You make a plan for getting the stay order. You
That
will
is
never
why,
make
sir,
any.
I am asking for the month of August.
August or
The learned-
medical problem, I cannot. I don't understand.
That I consider to your.
Learned Council for the informant submits that as the matter pertains to 2023, endeavor may be made to dispose of the matter on the next date. Full stop.
Yes,
The records are here. All the records are here. The scanned PCR. You have the because we need the case diary also. Case diary, charge sheet, everything will need.
Yes, no, sir.
You have no. Otherwise, we'll have to call.
This year is
This year is already.
PCR comprising case diary because to
Yes.
determine whether
Yes,
the
yes.
charge sheet is justified, you have to see the case diary.
Yes,
The scanned PCR is available. Full stop. List the matter on the 7/9/2026. Full stop. Because
And
the
interim-
diary is very important. The interim order by so and so stands extended till the next date of list. No issue.
This way of life.
Keep this also.
Item number 16.
To last name. Or rather, keep a hearing as a man.
May I please, your lordship? Am I audible,
Yes.
lordship?
Yes, you are
Lordship,
audible.
this matter has come up today for hearing, final hearing. But I don't know
Final
whether-
hearing of the appeal. Finally,
Yes,
Mr.
lordship. Yes.
What is it? Final hearing
Yes,
of the
lordship.
appeal.
Lordship. Now, lordship, here what has happened? I am behind the bar since lordship 9/1/2023. 3 years, 7 months have already passed. I am behind the bar. So if your lordship will take it up today or lordship may fix up some other day, it is up to your lordship.
We can commence the hearing, but it may not
Lordship,
be completed today.
It may not be
Lordship.
May
followed.
not be,
Detail-
no, it may not be, but I'm here remaining 3-4 days. I'm here. So we can
Lordship.
take it up tomorrow, part third again.
Lordship,
Lordship.
day after tomorrow already one matter fixed, Lordship. After that, Lordship,
Day after tomorrow, I can fix it, but the division bench
yeah, yes,
is there. Would you like to do it on Friday?
Lordship, let me start today. Little bit, let me do it, and then again on Friday I will try to finish it off, lordship. At least my part.
Because 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 it has to be completed. Because otherwise I'll have to hear by VC.
Yes, Lordship.
This, now you are appearing by VC, then if it does not get completed this week, then I will have to come to your, come in your place and hear by VC.
Lordship, Lordship, I will try to complete it today itself, my part. Then on
Because I'll
Friday,
be
we'll
rising at 4:30. Tomorrow we do not know what is the schedule.
tomorrow, Lordship, we are having some difficulties because tomorrow at second half we can do it, Lordship, if your Lordship allows us. Now, Lordship, let me just start. It is not so lengthy. It is very small because I am relying upon around 8 witnesses, and I will convince your Lordship that there is in fact nothing against me, and there is some blatant disregard of Section 52 of the NDPS Act. Lordship, may kindly see page number 82 of the paper book.
Let us hear till 4:30 then.
Lordship.
Okay. You do half an hour, I'll hear you, huh? Because I have to rise
Lordship.
at 4:30. And
Lordship,
then
Lordship.
we'll fix it tomorrow only. Tomorrow you have some difficulty, no? Tomorrow you have some difficulty.
Tomorrow we can do it in the second half, Lordship.
Yeah, we'll do half an hour.
Yes, Lordship.
It's not bad to do it in installments sometimes. We'll do till 4:30 today, whatever is done. And tomorrow we'll again fix it. But both of you have to just try for one thing, that complete the hearing during my stay only. Huh? Otherwise you will have inconvenience. We can still do it, but still we have to hear by VC. It's better. Okay, proceed.
Lordship, may kindly come to page number 82, Lordship. 82 of the paper book, Lordship. Convict Biswajit Narzari is sentenced for 10 years rigorous imprisonment and payment of fine of rupees 1 lakh for the offense of transporting commercial quantity of cannabis under Section 20 B2C NDPS Act. In default payment of fine, the convict is to undergo further simple imprisonment of 3 months in addition to the above statement, which the court will consider to be served for the purpose of the justice. So, Lordship, I was convicted for 10 years of imprisonment with a fine of rupees 1 lakh for transporting commercial quantity of cannabis under 20 B2C. Now, Lordship will kindly find the FIR is in page 1, Lordship. Lordship, what has happened? I'm just coming to the cracks because I will read out the statement of the informant, Lordship, which is more important, Lordship.
Yes, FIR
Page
is
one,
the page.
page 1, Lordship. P exhibit number 8.
Okay.
Paper I'm totally reading the paper book, Lordship. I'm referring
I'm
to
also
the
on the
paper
paper
book.
book. Yes.
Lordship
I'm
will
also on the
kindly
paper book.
Lordship will kindly find page 1. Your Lordship is kindly
Yes,
find it,
yes.
Lordship.
Yes, I'm on the paper book. Please go ahead. I'm on the
Okay.
FIR. Please go ahead.
Yes. So regarding lodging of the FIR, with due respect, Inspector so and so, hereby produce under mention one person, namely Biswajit Narzari. And the crux of the FIR says, Lordship, that on 6/10/2018, we got information around 14 hours from INT branch, blue color Alto K10 vehicle, bearing number AS27 A7077, coming from Kalaktang site. Special checking team was launched at MEP gate area. One team under the commandership of Inspector GD Payaloki Lotha. Two other team under the commandership of Santosh Kumar, Deputy Commandant person suspected the vehicles from Kalaktang. Lordship, what has happened? I was stopped. The vehicle was stopped. They have alleged that I have tried to run away, but thereafter they arrested me, and during checking up, they have seized some contraband. Now, this is the backdrop of the prosecution case, Lordship. Lordship will kindly come to page number 50 to 51, Lordship, of the paper book. This is very important. 50 to 51 is the statement of the informant. I will satisfy your Lordship that there was no any magistrate or any gazetted officer present when these seizures were made. 50 to 51, Lordship. Your Lordship has kindly find it, Lordship, page 50. May I read it, Lordship?
Yes.
He is the informant, Lordship.
PW6.
PW6, Lordship. On 6/10/2018, I was discharging my duty as Commander BOP 900 chain. On that day, we received information regarding transportation of contraband substance, and accordingly, we conduct NACA checking. During the time of checking one Alto K10 vehicle, bearing registration number AS27A7077 came towards the checking point. On being signaled to stop the vehicle, the driver stopped the vehicle and tried to run away. While running away, the driver fell on the road, sustained rashes on the knee. SSB person present on the duty has apprehended him. During checking the vehicle, we have recovered 7 plastic bags containing suspect ganja 29 kg. Accordingly, we have handed over the accused Vishwajit Narjari and the contraband with vehicle at Kalaktan. I have also prepared seizure memo and apprehension memo of the suspected ganja accused person. I have filed a FIR at Kalaktan PS. P exhibit 1 is the seizure list. P exhibit 2 is the seizure list prepared by me. P exhibit 8 is the FIR. Now, Lordship, I would just like to say one thing here. The seizure was made on 6/10/2018. Lordship, I kindly note this date, Lordship. It is very important for us when we proceed further, Lordship. Now, Lordship, I kindly come to page 51. That is the cross part. The NACA was conducted on prior information. Information was specific with color and registration of the vehicle. The information was not written down at office. Before the NACA, I have not intimated my commanding officer. During the NACA, I have not intimated civil police and magistrate. So magistrate was not there at all, Lordship. There was time for intimation about the information, but for information to TOT, the checking fails due to leakage of information. As I have not informed to anyone before checking, it is a fact that during seizure there was no civil witness. The vehicle was searched by my staff in my presence. The seized material were scaled by my staff. I was not present during the time of scaling. The seizure memo, etc., prepared by my clerk, and I put my signature. It is a fact that the seizure memo was prepared at PS and not BOP. I have not taken photographs during seizure. It is a fact that I have not sealed the contraband substance after recovery. I have handed over the same at PS and we have seized. It is a fact that there is no MR number. It is not a fact that I have falsely implicated the accused. There, Lordship will kindly see, there is no mention regarding any Malkhana register and nothing was produced before this court while these contrabands were produced before the Honorable Court, Lordship. Now, Lordship may kindly come to page number 48 to 49, that is the executive magistrate, Lordship.
Page 48,
48 and 49, Lordship. The magistrate.
PW 6, 5. Yes.
Lordship, PW 5, Lordship.
5.
Lordship. I am appearing in the court as I was ADC Kalaktan and destroyed the seized cannabis in connection with this case. Other case, in capacity of the magistrate, I participate in the instant case. P exhibit 4 is the application of the certificate of correctness of the inventory photographs and sample of the seized contraband prepared by the IO. P exhibit 5 is the correctness certificate issued by me in respect of P exhibit 4 and P exhibit 5. A is my signature on it. P exhibit 6 is the correctness certificate issued by me in respect of P exhibit 4. P exhibit 6A is my signature on it. M exhibit 1 to 3 are the photographs of the seized ganja. M exhibit 4 to 12 are the photographs taken at the time of carrying out the destruction of the seized ganja shown in P exhibit 4. P exhibit 7 is the destruction certificate issued by me in respect of M exhibit 1 to 12. Now, Lordship may kindly consider the cross, Lordship. It is fact that P exhibit 4 to 7 were prepared by police and I have just put my signature on it. It is fact that I have not given permission order to the police for the destruction of the cannabis in the present case. It is fact that the seized cannabis of the other cases were destroyed together. It is fact, this is very important, Lordship may kindly see, it is fact that the seized cannabis of the other cases were destroyed together. It is fact that I have not separated the seized cannabis in this particular case. It is fact that I cannot say the collected samples were drawn from the seized cannabis in this particular case or not. I do not remember whether the destroyed seized ganjas were under wax sealed or not. It is a fact that I have not seen the content of the bag. It is fact that in P exhibit 4 to 7 does not bear the date. It is a fact that I did not know about the fact of the case, how it was seized. It is not a fact that I do not know from where the seized contrabands were brought for destruction. It is a fact that M exhibit 4 to 12 was developed after the destruction and I do not know where it was developed. It is a fact that while preparing P exhibit 4, the seized contrabands were not shown to me. It is a fact that I cannot say the seized contraband shown M exhibit 1, 2, 3 belongs to the present case or not. So this is the evidence of the magistrate. Lordship may kindly see. Now, Lordship, here what has happened? Seizure were made on 6/10/2018. Samples were sent to FSL on 11/12/2018, and the report were received from FSL on 31/1/2019. This is how it was carried out, Lordship. Now, Lordship may kindly come to. May I continue, Lordship?
Yes.
Lordship may now kindly come to PW 7, Lordship 52, page 52. That is the witness from the FSL department. I'm finishing the important witness, then I'm concentrating on Caesar and the IO.
No issue. 52, yes, please.
52, Lordship. Presently, I am serving at PTC Bandardava in the department of FSL. As per the record of our office, sample relating to this case is received for examination. The sample is examined by the scientific officer as Iboma Devi. On examination, it is found that the sample to be cannabis and came within the purview of NDPS Act. On completion of examination, report is prepared by scientific officer and forwarded to the SP West Kaming. P exhibit 13 is the FSL report. 13A is the signature of S. Ibomi Devi, which I can identify. M exhibit 13 is the sample returned after examination. Now the cross part, Lordship, may kindly have a look, Lordship. I do not know when the FSL report was prepared by the scientific officer. I do not know the fact of the case. I do not know the quantity, quality, and color of the packet containing the sample. I do not know when the sample was received by the scientific officer and when it was returned. I have not participated during the time of examination. I am not the proper subordinate officer of S. Ibomi Devi, but I worked in the same office. So this is the evidence, Lordship, may kindly have a look. Now, Lordship, may kindly come to the Caesar witness. This is also very important. PW1, page 44, Lordship. The Lordship has kindly find it, Lordship. Page 44.
Yes,
I have
PW1.
PW1. I have come to the court as a witness in the case of Bishwajit Narjari. On 6/10/2018, at 900 hours, 900 chain, during surprise checking, the accused was apprehended along with suspected ganja. He was coming into an Alto car. The total suspected ganja was around 29 kg. Later on, I handed over the accused along with the ganja to OCPS Kalaktan. During the surprise checking, we were 4 personnel conducting the checking. Mr. P. Lotha, inspector, was leading the checking, and Mr. A. Shankar was also participated in the checking. P exhibit 1 is the seizure list of all the seized items. P exhibit 1 by A is my signature, which I put before the police. P exhibit 2 is the seizure of the SSB personnel. P exhibit 2A is my signature. I am not sure whether the accused standing on the dock is Vishwajit Narjari or not. As the standing person on the dock seems to be fair, I saw him once at the time of apprehension. As such, I do not properly remember the face of the accused. Now the cross-part, Lordship, may kindly have a look, Lordship. I have seen the suspected contraband at the time of seized. I do not remember the contrabands were weight or not at the time of taking over by the police. I do not have any knowledge of the vehicle was personal car of the accused or it was a hired car. P exhibit 2 was prepared at spot. Weighing machine was not electronic, it was manual. It is not a fact that I did not seize the car along with the contraband. It is not fact that we did not apprehend the accused and implicate a false case against him. Police did not collect the sample in my presence. The distance between PO and PS around 15 kilometers. It can also be possible that there may be manipulation of seized contraband in between PO and PS. Re-examination by the PP in the present case, there was no such manipulation of seized contraband from PO to PS. This is clarification given. Then next, Lordship, may kindly have a look to page number 45, Lordship. PW2. He is also Caesar witness, Lordship. I have come to the court as a witness in the case of Bishwajit Narjari. In the year 2018, at 900 chain, we intercepted a vehicle and seized suspected ganja from the vehicle. There were many SSB personnel participated in operation, out of which I remember Mr. P. Lotha and PW1. The apprehended person was from Assam. Later on, I handed over the accused along with ganja to OCPS Kalaktan. P exhibit 1 by B is my signature. In P exhibit 1, which I put before the police, P exhibit 2 is my signature on the seizure list prepared by my senior officer. The distance between the PO and PS is around 20 kilometers. Now, Lordship, I am reading the cross part, Lordship. The seizure items were not shown to me by police. I do not witness the sample collection by the police. P Exhibit 2 was prepared at BOP, not at the PO. I did not have any knowledge if the vehicle was personal car of the accused or it was a hired car. It can also be possible that there may be manipulated of the seized contraband in between PO and PS. It is not a fact that I did not seize the car along with the contraband. It is not a fact that we did not apprehend the accused and implicate a false case against him. Re-examination by PP. In the present case, there was no such manipulation of the seized contraband from PO to PS. The seized items were brought by us and handed over to the police, and thereafter P Exhibit 1 was exhibited. It is not necessary to show me the seized items by the police, as it was handed over to the police by us. Recross by defense. The seized items were handed over to the police by my senior officer and not by me officially. However, I personally witnessed the process of handing and taking over. Now, Lordship has already seen two witnesses, two seizure witnesses, and both of them evidences shows that there is some disparity in the seizure that has been already conducted, Lordship. Now, Lordship, PW 46, Lordship may kindly have a look, Lordship. Very small evidence, Lordship. I have come to the court as witness in the present case. I have witnessed as a Jimba witness. This is not so important. We can skip it, Lordship. Then PW
4.
4 also is not so important.
Jimma witness.
Lordship, Jimma witness. Lordship may come directly to PW 8. He is the IO, Lordship. Page 53, Lordship. His evidence is very important. On 6/10/2018, I was posted at collecting PS as OCPS. On that day, one written FIR was received from Inspector P.O.K. Lotha of 61 BN SSB. It is alleged that on 6/10/2018, at around 1400 hours, basing upon input, the SSB personnel have conducted checking of one Alto K10 bearing registration number AS27A7077. During the time of checking one Alto K10 vehicle bearing registration number AS27A7077 coming towards a checkpoint. On being signaled to stop the vehicle, the driver stopped the vehicle and tried to run away. While running away, the driver fell on the road and sustained rashes on his knee. SSB person present on the duty has apprehended him. During checking, the vehicle has recovered 7 plastic bags containing suspected ganja measuring 29 kg. Accordingly, they have handed over the accused Vishwajit Narjari and the contraband with the vehicle at Khalakhtang PS. On receipt of FIR, I have registered Khalakhtang PS case number 15 of 2018 under Section 20B NDPS Act and undertook the investigation. During investigation, I have arrested the accused person and received the ganja produced at the PS. I have forwarded the ganja for FSL examination. I have recorded statement of informant as well as other available witness. I have taken photographs of the seized ganja car and accused persons. I have visited PO and drawn rough sketch map PO. I have prepared inventory of the contraband ganja and took photographs of the same, and the same is placed before the magistrate. On my prayer, the contraband substance was tested by magistrate. On completion of investigation, I have filed the charge sheet against accused Vishwajit Narjari. Accused standing on the dock is identified by me. Rest are his exhibits, Lordship. Now, Lordship may kindly come to page 50 of his cross, Lordship. It is a fact that the checking was conducted as per specific information. In FIR, informant has not mentioned as to whether the complainant has written down the information and intimated to his superior officer. The contraband was not produced at a PS with seal. The informant has not mentioned about the custody of the seized contraband before producing at PS. On P Exhibit 1 and 2, there is no independent witness. During seizure, no magistrate was present. This is very important, Lordship. May kindly have a note, Lordship. It is a fact that I could have called the magistrate, but I have not called, as usually magistrate does not come. During seizure, I have not taken photographs or video photographs. I have not mentioned date, time, weight regarding the sample sent for FSL. I have not mentioned regarding the custody of the sample. FSL was done prior to the inventory and sampling during distraction. I have collected the sample of 7 bags without mixing the same. I have not explained the delay in sending the FSL examination. I have not mentioned regarding custodian of the seized material. I have not personally scaled the contraband substance. Regarding the application of correctness and the inventory was made for several cases for together. This is also very important, Lordship. May kindly see they have mixed up with the other samples. During the certification of the correctness of inventory, I have produced the seized material before magistrate. It is a fact that distraction not made by board under the notification of union government distraction of metros are done together which are seized in other cases. The inventory was prepared after more than year of seizing the same. This is very important, Lordship. They have prepared the inventory after more than 1 year of seizing it. During the said period, the seized material was at Malkhana under charge of Kota IC. I have not mentioned about the same in the CS. It is not a fact that the accused is wrongly implicated in this case. It is not a fact that the investigation is not carried out on properly. It is not a fact that the inventory is not as per the format provided under Section 52A of the NDPS Act. Now, Lordship, in the entire case, Lordship may kindly see that there was not a magistrate or a gazetted officer present, Lordship, when the seizure has been made. Distraction has also not been made as per the NDPS Act, Lordship. In fact, he is saying that he has destroyed it after a period of 1 year. Lordship may kindly note this. If your Lordship kindly allows me, tomorrow I will come back with some citations and judgments. Lordship may kindly have a look at Annexure 4 of the IA, Lordship, page 81.
Annexure?
Annexure 4, page 81 of the IA.
Annexure 4 of the IA.
IA, page 81, Lordship. That is the inventory list, Lordship. Lordship will find that the inventory list has been made on 26/11/2019.
81.
And yes, Lordship, page 81, Lordship. If your Lordship kindly find it, Lordship.
Yes, I found it.
Annexure 4. Now, Lordship may kindly have a look at the date, Lordship. Date 26/11/19.
19.
Now, Lordship, the seizure was made on 6/10/2018, and inventory has been prepared on 26/11/2019, after more than a period of 1 year. So, Lordship, there is a blatant disregard of the provision of the NDPS Act, Lordship, in this case. Next page, Lordship may kindly see page 82. Certificate by the magistrate. That is also on 26/11/19. Your Lordship has kindly find it, Lordship. Page 83, Lordship will kindly find is the FSL, Lordship. FSL report date is 30/31. Page 84, Lordship may kindly have a look, Lordship. Report date is 31/1/2019. And the seizure was made on 6/10/2018. That means more than 1 year has gone. They have sent it for the FSL. They have kept the contraband. Now we do not know whether this contraband that has been seized is the same contraband in this case. The contraband that was sent to FSL and the contraband that was inventory was prepared, whether it is the same contraband which was seized from us, we do not know, Lordship. Lordship, there is a blatant disregard of the entire NDPS Act in this case, Lordship. I have shown your Lordship. Tomorrow, if your Lordship kindly allows me, I will produce some judgment and citation before your Lordship.
Okay.
Okay, Lordship.
Okay. So we close here today? Huh?
Yeah,
Just
Lordship,
take this.
my reading of deposition is closed. Tomorrow I will sum up my argument,
Okay,
Lordship.
that's fine. We can complete it. Third.
Can it be at 2, Lordship? Can it be at 2 tomorrow, Lordship?
It will be in second half only. We'll keep it flexible.
Lordship.
As per,
I am deeply obliged.
We'll keep your convenience in mind, since you are
I am
appearing
deeply obliged, Lordship.
from principal seat. Okay, we'll adjust
I'm
it.
deeply obliged. I'm deeply obliged, Lordship.
Learned counsel appears to online mode from Gauhati. Full stop. Also, the learned additional people and Hage is present. Full stop. The arguments are addressed by the learned counsel for the appellant, but they are not completed today due to paucity of time. Matter may be kept as part heard. List tomorrow. That is 5/8. Okay.
Deeply obliged.
Okay.
Item number 17, it's an unlisted motion matter.
Made, please, your Lordship. Lordship, I will be very highly obliged. If Lordship will just bear with me 2 minutes only.
Yeah,
Sir,
just a minute. This is a BA. Huh?
Yes.
Go ahead, please. He was arrested on?
Yes, Lordship, the accused was arrested on dated 4th July 26. Subsequently, he has been languishing behind the bar for 31 days till today, Lordship.
Right.
Lordship, the section which has been alleged is section 305 clause B of BNS. Lordship, this is a theft of a means of transportation. It prescribes the punishment for imprisonment which may extend to 7 years and a liability of fine. Lordship, this is non-bailable, non-compoundable and a cognizable offense. Lordship. Now, Lordship, the whole case had arose upon one FIR dated 16 April 26 by a complainant, namely Bamang Takar, who had filed one missing FIR that his vehicle
Page?
Lordship, that is page number 6, Lordship. There is only a missing FIR stating that his bike, namely Royal Enfield, was kept near the Secretariat premises and it was lost. So subsequently, Lordship, during the course of investigation, this matter was endorsed and forwarded as an FR before the magistrate because they could not apprehend the accused person. But however, Lordship, coming into this case, on 4th July 26, the accused person was arrested in possession of another scooter. So on that very day, he was brought to the police station, and later on, this police investigation agency, they have registered this case also, reopened the case, and registered against him another case. Lordship. This is the particular case. Now, Lordship, 2 times.
Yeah, but the FIR pertaining to this particular case.
Yes, Lordship. On that another case, Lordship.
I want to see the FIR pertaining to Itanagar 97.
Yes, Lord.
Okay, first let us see that. Itanagar 97. Page 23.
Page 23, Lordship.
This is the forwarding report, sorry.
Yes. Lordship, this was the FR case. That's why we could get only these materials from the learned courts also. If I may read, Lordship, only this para.
Order investigation. Anyway. Okay. Page
23, Lordship.
23.
This is the forwarding submitted by the IO, Lordship.
Okay. You read it. Which para?
The gist of the case, Lordship. In order to understand the case. On 16 April 26, at around 4 hours, a written FIR was received from Sri Bamang Takar, aged about 27 years, son of so-and-so, resident of Itanagar, and permanent resident of so-and-so, that alleging that on 16/4/26 at about 02 hours, his motorcycle bearing registration number AR01 so-and-so, Royal Enfield, was stolen from Civil Secretariat Itanagar area. On receipt of the case was registered and endorsed to under. Lordship, this is the case only that it was reopened. It has been mentioned in the 3rd paragraph saying subsequently on 4th July 26, Sri Munchidayam, aged about so-and-so, resident of so-and-so, was brought to police station Itanagar by SI NS so-and-so after he was apprehended in possession of the stolen scooter, TVS scooter, bearing number so-and-so, which is under investigation by SI so-and-so. During the interrogation, it is said that the accused was confronted with the CCTV footage collected from Indus Lane area, Itanagar so-and-so, in connection with the present case. Upon carefully viewing the footage, he voluntarily admitted that he was the person seen stealing the Royal Enfield so-and-so, bearing number so-and-so, from near Indus Lane. He further disclosed that after committing the theft, he sold the stolen motorcycle to one Sri Ibrahim Ali for a sum of ₹5,000. As fresh, credible and material evidence had emerged after submission of the final report and under direction of the officer in charge, the investigation of ITA PS was reopened for further investigation. Later on, Lordship, this is the case only, he was arrested.
Further investigation.
Yes.
For the further investigation. He was shown arrested in this case.
Yes, Lordship.
He was shown arrested in this case.
Lordship, we have filed the application 2 times. Once on dated 16 July before London Jam FC Naharlagan. but the same was rejected
Okay.
on the ground that considering the gravity of the offense.
Oh,
And
that's
also
okay.
saying, yes, Lordship. Again, Lordship, on that rejection, in fact, we also agree on that part because it was at the nascent stage.
Oh,
Police has to
okay.
complete the investigation.
So, this petition, shall we call for the case diary at this stage? Or any other submission you have?
So far as my lord, the court is not considering the interim, my lord, I will not make submission. I will reserve my submission at this stage. my
Are
lord.
you, he's not paying for
Yes,
interim.
call
Are
for
you paying
case
for
diary,
interim pay?
Lordship, there is something I just want to
Yes.
bring in the appreciation.
Yeah, please. You
Lo-
complete your submission. I thought
Yes.
you had completed.
So first time the learned JNFC have rejected.
Mm.
So in fact, we also agree on that.
Mm.
Again, subsequently, we had filed a bail application before the Sessions Court
Mm.
on dated 27 July 26. Lordship.
Mm.
Lordship, page number 39. I'll humbly like to invite Lordship attention on page number 39.
39.
Lordship, the matter was fixed for bail hearing. The CD was there. But however, Lordship, during the course of time, I just want to bring in the appreciation also. Lordship,
Page number 30?
39, Lordship.
39.
40, there is variation in the page number, my
The
lord.
39 is a medical document.
Yes, my lord.
I
There
think
is a
we are
slight
not on the
variation
same
in-
page. What is the content of the page?
my lord, it should be page number 40 in your your lordship
40?
petition. 40, yes, my lord.
Oh, the order.
Yes.
Order of
Yes,
the
Lordship.
session, judge. Oh, 27/7/26.
Yes, Lordship.
Ah.
Lordship, here I have some of the grievances which I humbly want to submit. Lordship. I just want to read, Lordship, para 3, Lordship. Heard submission made by the learned counsel appearing for the accused person. It is submitted that ITA PS case number so and so registered by filing the FIR on dated 4/0/26. Lordship, this is wrong. That FIR dated is 16 April 26.
Yeah, okay.
Again, Lordship, alleging that Royal Enfield so and so was where it is submitted that accused Ringu Rate. Lordship, this is a wrongful name. Accused name is Munchi Tayam, Lordship.
He is mixed up.
Yes, Lordship. It might be typical problem. Be that as it may, Lordship. Before the court of learned JMC was rejected due to the gravity of the offense so and so and so. Lordship, again, I just want to come on the next page. That is a para number 4, Lordship. Lordship, here it has been implicated in the order that heard submission made by learned counsel of the state. This indicating to the PP, learned PP, Lordship. It is submitted that gang of the vehicle lifter are actively operating in the state of Arunachal Pradesh, specifically in the capital region. It is submitted that investigation agency be provided a sufficient opportunity to conduct a proper investigation into the case, and the application to release the Munchitayam be rejected at the stage of investigation. Lordship, what I very humbly submit, Lordship, I was the counsel who had done the hearing. During the time, in the presence of court, there was no PP at all. So that's why the matter was heard on 27 and the order was given to us on dated 30, Lordship. In fact, it is not I who submit. In fact, the learned PP also submit that he was not there during the time. But also here, very clearly, it has been implicated that the state was represented by the learned PP. Now again, Lordship, para number 6. In view of the above material on the case record, it is observed that accused Munchi Taime, again, Lordship, there is a mistake. So these are the things.
So anyway,
These are typographical.
no, still should not be made.
Lordship,
But now we can take an independent call. I mean,
Yes,
since
my
we are
lord,
not
my lord,
sitting in revision or appeal.
Yes, my lord.
But yeah, I mean,
My lord, the issue that my brother has highlighted that in absence of PP, my lord, I don't think, my lord, this is the appropriate forum for the consideration of bail, wherein, my lord, this extract will be considered.
yes, 528 is there.
but he's pointed it out.
Yes, my lord.
So it's okay.
Lordship, why I'm only submitting on this part is just I'm just seeking for some benefit because we have been agreed even on before the Honorable District and Session Court, some sort of benefit be given to us upon this. That's why only I'm.
I don't think, counsel, I don't think it is a case of interim because
Yes, my lord.
there seems to be ongoing investigation into some other thefts also.
Yes, my lord. Other thefts also, and my lord.
I will you get the case that.
Yes, my lord. And my lord.
Itanagar only.
Yes, my lord.
Itanagar.
My lord, may fix it. My
Day after tomorrow.
day after tomorrow.
Day after tomorrow. Or latest by Friday.
My lord, Friday, my lord, some other my lord council, Friday I have a difficulty, my lord, on Friday.
Day after tomorrow,
Day after tomorrow, no issue, my lord.
you try. Learned counsel. Your
Yes,
good name,
Intil.
please.
Yeah.
Your good name, please.
S. Intil, Lordship.
Learned counsel appearing for the. I won't write much with this. Appearing for the petitioner seeking bail hearing in exercise of powers under 483 BNSS. Full stop. He was shown arrested in this case on 4/7/2020. He was shown arrested on 4/7/2026 in connection with Itanagar PS case number 97 of 2026. Full stop.
Fifth, my lord, on fifth, my lord, not on fourth.
On 5th.
Fifth, yes, my lord.
Full stop.
The remand was also passed on fifth only.
On 16/4/2026, FIR was lodged by one Baman Tarak at the Itanagar PS with regard to the alleged theft of his Royal Enfield vehicle, two-wheeler, bearing number AR01T1956. Full stop. On the basis of the same, Itanagar PS case number 97 of 26 was registered under section 305B BNS. Full stop. Subsequently, due to lack of sufficient evidence, the IO submitted final report being FR number 130 of 2026 dated 9/6/2026. Next paragraph. Thereafter, on 4/7/2026, the present petitioner was brought to the police station upon apprehension in connection with Itanagar PS case number 78 of 26 pertaining to theft of two-wheeler. And during his custodial examination, it emerged that he was also involved. He was also purportedly involved in the alleged theft pertaining to Itanagar PS 97 of 26. Accordingly, the further investigation was started in Itanagar PS case 97 of 26, and the petitioner herein was shown arrested in this case. He was shown arrested on 5/7/2026. At this stage, call for the we'll call for this case diary only.
Yes, my lord. This
It's not related.
Yes, it's not
So that's another. Call for the scan case diary, right?
Yes, yes,
Scan case diary of Itanagar 97 of 26 on the concerned police station. List on Thursday.
Hello.
Thursday will be 6th.
my lord. Sixth, my lord.
Hello.
Obliged, man. Thursday, many division bench matters are listed, my lord. Even my appeal is also fixed, my lord. So whether the single bench matter will be.
This will not take much time.
Yes,
If